This affidavit, by the way, is evidence of abuse of authority, abuse of power, and government corruption. And I'm glad Judicial Watch got it out. So when they say that the president had records in violation of the law, he should have, and he should reject that very notion. All of these records are his, all of them are personal, at least the way the Justice Department used to think about the law. And I talked to you about this case, and it's worth reiterating because, you know, the left media is all excited about the fact that I may or may not have talked to President Trump about this issue. But they didn't want to talk about as much whether my public statements about what the law is and how it should apply are correct. And it's worth reiterating what a district court judge here in Washington, D.C. found when she looked at information that was kept by Bill Clinton, tapes of conversations he had with foreign leaders and doing other government business. And we had seen initially, hey, they're presidential records, as I've said. And the court came back and said, no, you can't force the archives to do anything about this. And she explained what the law was. And the law is, according to her, and this is Judge Amy Berman Jackson, who's one of the more liberal judges here in the District Court of the District of Columbia. And she did this at the request, by the way, of the archives, that now's done a completely, now's pretending this decision doesn't exist. I want you to listen to this and you think, and ask yourself if you think her analysis would allow this raid to have taken place. Quote from the judge: under the statutory scheme established by the Presidential Records Act, the decision to segregate personal materials from presidential records is made by the president during the president's term and in his sole discretion. So NARA, the National Archives, could not make a classification decision different from that of the president. Again, since the president is completely entrusted with the management and even the disposal of presidential records, you hear that? Disposal. During his time in office, it would be difficult for this court to conclude that Congress intended that he would have less authority to do what he pleases with what he considers to be his personal records. Again, the Presidential Records Act contains no provision obligating or even permitting the archives to assume control over records that the president categorized and filed separately as personal records. At the conclusion of the president's term, the archivist only assumes responsibility for the presidential records, meaning the ones that they know have been sent over to them as presidential records. Plaintiff, Judicial Watch, contends that its factual allegations about the nature and substance of the audio tapes at issue clearly establishes them to be presidential records, regardless of how they were treated by President Clinton. The court is not so sure. But even if the court were inclined to agree with our reassessment of President Clinton's decision, it would not alter the conclusion that the injury cannot be redressed. And this is the kicker. The Presidential Records Act does not confer any mandatory or even discretionary authority on the archivist to classify records. Under this statute, the responsibility is left solely to the president. While the plaintiff casts this lawsuit as a challenge to a decision made by the National Archives, the Presidential Records Act makes it clear that this is not a decision the archivist can make. And in this particular case, it is not a decision the archivist did make because President Clinton's term ended in 2000 and the tapes were not provided to the archives at this time. So there you have it. A court decision that quite persuasively, we lost. We lost this, so we know what the law is. You know, we generally know what the law is because we're in litigation, but we really know what the law is when we lose a lawsuit because you never like to lose. And we lost this one. And here you have a district court judge interpreting an appellate court decision that was the guiding decision for the government's handling of presidential records and saying, no way the archives can come in and get these records. No way. There's no enforcement mechanism, and yet they went ahead and pretended there was, and they concocted and told a judge, in my view, misled a judge, that he had the authority under law to authorize a warrant to get presidential records. And don't be distracted by the fact that there were so-called classified records in the boxes that weren't presidential records. Classified records are a subset of presidential records. So if he thinks they're personal, it means they're already declassified. There was no authority for the Justice Department to ask a judge to authorize a subpoena to enforce the Presidential Records Act. And obviously, the judge had no authority to implement or approve a warrant that had no basis in law. That's what happened here. So this affidavit, by the way, is evidence of abuse of authority, abuse of power, and government corruption. And I'm glad Judicial Watch got it out. And once again, this affidavit and these documents further confirm just how dishonest the Justice Department is. I talked about how in this case, they refused to go after Clinton records. Well, are they now going to go after Clinton records? I doubt it. Of course you know. They're not going to do anything like that. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.